This is part of a larger project that we are just kicking off in the Government Attorneys Interest Group at ASIL. The idea came up in discussions that in everyone's imagination and maybe in a simpler time, a foreign ministry, in the case of the United States, the State Department, is in some sense responsible for international law for the government and international relations. Certainly, there are still aspects of that within the U.S. government. There's something called the CASE Act that requires that international agreements, including international treaties and executive agreements, get clearance from the Secretary of State. And as a practical matter, they are funneled through the Office of the Legal Advisor Treaty Office, known as LT. But of course, reality is much different than theory. And in an increasingly global environment, both technically and economically, and certainly legally, international law reaches into really every aspect of the executive of the US government, and we suspect the executive branches of every government around the world. International law and international relations are not simply a matter of U.S. State Department practice anymore. They are literally practiced every day by almost every executive agency. Our goal with the project that we're starting tonight is to start to explore how agencies address international law, what sorts of issues they have to deal with, how they discern the content of international or foreign law, what sorts of cooperative relationships exist between agencies. And I'm pleased that I'm joined tonight by lawyers from many different diverse agencies to address those questions. First, starting on our extreme left, my extreme left, your right, is Jennifer Thibodeau. Jennifer is a senior attorney in the Office of the Assistant General Counsel for International Law at the U.S. Department of Transportation. She works on a variety of international transportation issues. In particular, in the area of international aviation, she deals with such matters as bilateral air services, agreement negotiations and interpretation, regulatory issues, and issues involving the International Civil Aviation Organization. Jennifer is also the primary attorney at the Department of Transportation that handles matters relating to the North American Free Trade Agreement and other free trade agreements. Let's move in order. So next we have Megan McMillan. Megan is an attorney in the Commercial Law Development Program at the U.S. Department of Commerce, Office of the General Counsel. Ms. McMillan primarily advises governments in the Middle East and North Africa on legal reform and economic development issues. Prior to joining the Department of Commerce, she was an attorney advisor for the U.S. Department of Justice in the Office of the Rule of Law Coordinator at the U.S. Embassy in Baghdad, where she acted as the office's Kurdistan Regional Government Liaison and managed the Commercial Law Development portfolio. To my right is Catherine Cooper. Catherine is an attorney who is not currently practicing as an attorney, correct? She is currently the Deputy Director of the Office of Strategy, Partnerships, and Analytics in the Food and Drug Administration's Office of International Programs. Prior to that, however, she was the Associate Chief Counsel at the FDA for International Affairs. In this capacity, she advised FDA's component centers and offices on legal matters arising in the context of FDA's international activities. In addition to food and drug law, information disclosure law, and administrative procedural law, her work included the negotiation and implementation of multilateral conventions, USG-level international agreements, and agency-to-agency international cooperative arrangements. To Ms. Cooper's right is Gary Sampliner. Gary is the Senior Counsel at the Office of General Counsel International Affairs at the U.S. Department of Treasury, where he has served since October of 1998. At Treasury, Mr. Sampliner has served as the department's counsel in all bilateral investment treaties and the investment chapters of free trade agreements negotiated by the U.S. government. He also assists in the defense of arbitration claims and preparation of U.S. submissions in investor-state arbitrations, addressing requests for U.S. government assistance from U.S. investors overseas, legal oversight of U.S. participation in the multilateral development banks, work on the Committee on Foreign Investment in the United States, and he works in international anti-corruption efforts. Finally, to Gary's right is Judith Cohen. Judith has held a variety of international tax law positions at the Internal Revenue Service, or IRS. Currently, Ms. Cohen is a senior manager in the Advanced Pricing and Mutual Agreement Program, APMA, in the Large Business and International Division of the IRS, and I'm hoping that tonight she'll explain what that means in more detail. There's a little bit more detail provided in the bio. I have to admit it doesn't provide me much clarity. So, among her many roles, she manages a group of professionals, almost entirely attorneys, in developing transfer pricing tax positions from an economic and legal standpoint, and then negotiating these cases with foreign government officials. She's also responsible for managing and coordinating her office's negotiations with several countries, including Australia, Germany, the Netherlands, and Israel. So as you can see, we have a breadth of experience on the panel tonight, and we're hoping that they can give us some interesting insight about international law in the U.S. government. I'd like to, we won't be asking all questions of all of our panelists, but I did want to say at the outset that it's a little unfortunate that we have this large gap between the dais here and all of you. We are hoping this will be a bit interactive, so if you have questions, feel free not to wait until the end. If there's something you'd like to know about that comes up in the context of our discussion, please feel free to raise your hand and ask your question. So as we begin, I would like to ask each of our panelists, starting with Jennifer, what legal issues your agency addresses, international legal issues your agency addresses, or your particular office within that agency addresses?
Well, my office is small, but we actually deal with all of our operating administrations at the Department of Transportation. So basically the easiest way to do it would be to break it down by mode of transportation. So aviation, we deal with safety and economic agreements, and that deals with the FAA and the Office of the Secretary. We deal with ICAO, the International Civil Aviation Organization. Environmental agreements and environmental issues. Most notably in the news recently has been the EU's emissions trade scheme that was proposed and has recently been voted to be scaled back. We were heavily involved in that, and the Secretary in particular, for land transport, so that includes motor carriers, rail, and cars for that matter. And even in cars we deal with infrastructure issues, bridges, cross-border issues, obviously with Mexico and Canada, ownership and control of rail, as well as trucks. There's a convention called the Cape Town Convention that deals with secure transactions of planes, and there's a new part of it that's dealing specifically with rail. The National Highway Traffic Safety Administration is actually party to a United Nations Convention on standards for cars. So if you have a car in China, a car in India, a car in Sweden, a car in Mexico, a car in the US, they all look the same. There's actually a convention that says that. In maritime issues, we deal with the International Maritime Organization, the United Nations Convention on Law on the Sea, economic bilateral agreements, and then the Department of Transportation also houses the St. Lawrence Seaway Development Corporation, which is a binational agreement between Canada and the U.S. dealing with the St. Lawrence Seaway. And then also on top of all of that, we also have, we deal with the free trade agreements, NAFTA, WTO, CAFTA. NAFTA specifically is in aviation with specialty air services, which are like your crop dusters and helicopter issues. And then my particular thing that will keep me permanently employed will be cross-border trucking, specifically with Mexico. That's been an ongoing issue actually for as long as I've been at the department, and probably for as long as I'll stay at the department, an ongoing concern. And then WTO issues, I know we deal with TPP right now and ongoing issues like that.
Thank you. Meg?
I should start with a caveat that our office doesn't work on any pending legal matters, and we normally defer to the appropriate government office for interpretation of international agreements. But what we do offer is we're a technical assistance arm of the Office of the General Counsel in the U.S. Department of Commerce. And we regularly participate in USTR trade negotiations. And we design programs that educate foreign government officials on obligations under treaties. And but our practice, our work is a little bit oriented more toward foreign and comparative law. We design programs that utilize the expertise of U.S. Government experts and also private experts to help build capacity in institutions and systems abroad that make it easier for our U.S. businesses to do business abroad. So also in that vein, we in addressing certain issues our experts will refer to conventions or understanding of international best practices in business and commercial law.
Okay, Catherine.
Okay. Well, FDA's Office of the Chief Counsel, as well as my current office, Office of International Programs, are involved in a variety of international activities in which various legal questions can arise. One category would be questions that are governed by domestic law, such as the extent to which we can share non-public information with counterpart regulatory agencies in foreign governments, for example. We have regulations that address this issue, and just recently with the passage of FDASIA, the Food and Drug Act, FDA, anyway, with the most recent passage of the most recent update to the Food, Drug, and Cosmetic Act, we've been given some additional authority in that area. And this is a matter that comes up really quite often. We also, because our mandate includes regulation of imported as well as exported products, this can touch on international trade issues. So when we train the various centers and offices within the agency, we want to make sure that they're aware of what our requirements are. In terms of international trade law, we are particularly interested in the sanitary and phytosanitary provisions, SPS, as well as the technical barriers to trade provisions of the WHO GATT system. We are involved to an extent in certain capacity building activities. We've worked with foreign governments to train them on analytical techniques and so on. Again, here it's a matter of not so much doing international law, but US law in an international context. So we've done a great deal of that in the past. We're actually moving somewhat away from one-on-one government-to-government capacity building efforts, in the sense that there are so many countries out there and so many of them would like to be working with the FDA that we're trying to move toward larger fora now and get more bang for our legal buck there. We work on harmonization of technical requirements for the registration of new drugs, for example, but in many other areas. We also have a great many relationships with international or multilateral organizations like the WHO, the World Health Organization. Probably in the last 5 to 10 years, the FDA has become much more global in its outlook, and we look very actively to partner with some of these multilateral organizations so that we can leverage resources and achieve our common international public health goals. And finally, I'll just mention that for about 5 years now, we've had foreign posts located in certain foreign countries: China, India, European Union. We have an Asia-Pacific office, which is actually located in the United States, and South America, Central America. We also have one-person offices to cover the Middle East and North Africa and Sub-Saharan Africa. So that, again, is just a reflection of how very global our outlook has become and how we recognize that it has to be, given that some enormous percentage of the food and the medical products that are used in the United States are imported from other countries.
Derek?
Okay. At Treasury, virtually every international economic issue of interest to the U.S. government is something that our General Counsel's office, or my office in particular, handles. And I'll start with my office, which is the Office of Assistant General Counsel for International Affairs. We deal with, first, international financial matters involving the International Monetary Fund, sovereign debt issues, and international payment system. Secondly, international trade and investment issues, and with the WTO, our free trade agreements, and bilateral investment treaties. That's the outward investment issues for our investors who are going overseas. And in addition, for inward investment, we are the chair of the CFIUS, the Committee for Foreign Investment in the United States, an interagency committee. Third, we do international financial regulatory cooperation matters, and ever since the financial crisis in particular, that's been a very active portion of our portfolio. And finally, for our office, Treasury is the lead agency for U.S. participation in all of the multilateral development banks, the World Bank, all the regional multilateral development banks, and some specialized ones like IFAD, the International Food and Agricultural, forget the D, stands for the Global Environmental Fund also. So that's our office. In addition, in Treasury, we have the part of our General Counsel office is part of OFAC, the Office of Financial Asset Controls, and all of our sanctions are done through OFAC, and there's a Chief Counsel's office there. Secondly, we have a TFI division, which is a division of terrorist finance and intelligence, and we have part of our General Counsel's office who reports to them as clients, and that is all of the international financial crime and other skullduggery involving money laundering, terrorist financing, and the like that they get involved in. And finally, and Judith will talk more about this, but we do have our International Tax Council at in headquarters of Treasury that deal with tax treaties. We deal with them quite a bit on our free trade agreements and bilateral investment treaties, as well as taxation matters involving members of the multilateral development banks and their staff.
Okay, thank you. Judith?
Thank you. Can you all hear me? Okay. I work for the IRS, which is under the, well, it's part of the Department of Treasury, as Gary said. And I'm sure you've all heard of the IRS. We've got, I've lost count, but hundreds of thousands of employees across the whole country and a lot of folks here in town. Obviously the IRS and council in particular deal with any kind of international tax issue that you could think of. I will focus on my particular agency, and it's a brand new one. It was just actually formed, it's really made up of two former organizations, and there was a recent merger. One, actually the head of it called it a hostile takeover, and we were about a year old, and now we're actually functioning as one unified organization. It's the Advanced Pricing and Mutual Agreement Program. I'll explain what that does. What we're dealing with, or actually what I'm in my particular division, is not only international tax only, it's transfer pricing. And transfer pricing, and this is where I'm going to get a little bit specific. Has anyone heard of it? Good. Many years ago, and I think it was in his very first State of the Union address, Bill Clinton mentioned transfer pricing and said, we're losing billions of dollars that's being shifted overseas. I mean, we're dealing with the biggest tax issues that there are. In transfer pricing, what we're doing is we're seeking to ensure that related parties, basically companies that are related, they're part of a multinational corporation. So they could have a parent here and a foreign sub, or vice versa. They could have hundreds of subsidiaries, many foreign. What we're doing is that we're seeking to ensure that these related parties are dealing with each other at arm's length, as if they were unrelated or uncontrolled corporations, when they're pricing the transactions between them. It could be just a simple sale of tangibles, like a sale of goods from the U.S. parent to a German subsidiary, or it could be a transfer of, it could be just like a provision of services, maybe the U.S., maybe the UK subsidiary is performing services for the U.S. parent, or it could or it could actually be a lot of the highest, most controversial issues are dealing with intangibles because they're easily movable, they're taxed where they're used, and they're so highly valuable. And what we're seeking to ensure is that these companies are pricing their, even though they're related, we want to make sure we're going to essentially put them on an unrelated, on an arm's length basis, the way unrelated or third parties would deal with each other, and make sure that they're not essentially playing games and transferring too much money, pricing it incorrectly and shifting profits overseas. Now, obviously, foreign governments have the same concern. They want to make sure that they get their fair share. And that's where my particular division enters. As I said, it's the Advanced Pricing and Mutual Agreement Program. And advanced pricing, or APAs, Advanced Pricing Agreements, we enter into these with taxpayers before any kind of audit. Taxpayers want certainty in how we're going to treat them. They don't want to be subject to major adjustments. So what they do is they'll come in, it's totally elective, this is good, we're not out there auditing, taxpayers like us, and we'll actually enter into an agreement, and we actually negotiate these with the foreign countries. These are called bilateral APAs, Advanced Pricing Agreements. Now, on the other hand, and so that was my division at first, it was the APA division, and that was by itself, but it worked closely with what was the U.S. Competent Authority Division, and that division dealt with basically when, sort of on the back end of things, when a taxpayer's been audited, and let's say it's subject to tax both here and then France has come in and audited it as well. And the same income is being taxed twice, once here and once in France. Taxpayers don't want to be subject to them. So we've got treaties, which Gary mentioned, international tax conventions. And we basically do everything through the treaties. And we negotiate, and the two countries sit down face to face. I'll be going to Germany in a month with a delegation, and we say, okay, we'll look at each case, and it could be a MAP case, which is the mutual agreement cases that I was just talking about, which are the double tax cases after audit, or it could be the advanced pricing agreement cases that taxpayers want certainty before, so there won't be an audit of those issues. And we sit down and we negotiate, we have positions, and we say, this is what, we end up reaching an agreement on what's right, on the proper tax treatment. And we work, in my particular division, not surprisingly, we work with a lot of economists, we work with accountants, and a lot of lawyers.
Thank you, Judith.
Did that help?
Yeah, it did. It made it very clear.
One person was nodding.
It makes me wonder if one day I can take advantage of one of these treaties. But speaking of which, let me ask you, used a couple phrases interchangeably, treaties and agreements. These advanced pricing agreements, are they executive agreements or are they formalized treaties?
They're not treaties. Okay, everything I've been talking about has been done in the context of a treaty. So we could not enter into a bilateral APA with a lot of the South American countries because we don't have an international income tax convention with most of these South American countries, which is surprising. Okay, but these advanced pricing agreements are just for the taxpayer. They're done in the context of the treaty. That's how it enables us to do it, to exchange the information, et cetera, et cetera. But they're literally just for that particular taxpayer.
Okay.
By the way, it's Treasury that we were talking about Treasury, IRS people in different divisions. If anyone here is interested in the IRS, and we're so big and there's so much international tax law, I'm just one division, feel free to come up to me. And I can tell you about the different divisions, but our folks work with the Treasury people actually in Gary's office, not his particular office, to actually negotiate a lot of these treaties. And Treasury sets the policy. So I just want to make that clear.
Catherine, let me turn to you with my second follow-up question. You mentioned a number of treaties that USTR is concerned about, including in particular the sanitary and phytosanitary provisions of those treaties. How does the FDA go about interpreting what is required from those treaties, either of FDA or of one of our, of a country outside of the United States?
Well, I should say first off that we don't consider it within our mandate to interpret international trade agreements. However, as I say, because we do so much work with imports and exports, international trade issues do arise. What I was generally involved in was making sure that the policymakers at FDA were familiar with the existence of these treaties, understood that the existence of GATT, for example, didn't mean that there was going to be a lowering of standards, that we could still maintain our levels of protection. However, that we were subject to certain requirements in terms of transparency, science basis for our actions, and so on. Generally, I think I'm fortunate in that FDA, I think, generally does most of these things anyway because of the APA and any number of other forces on FDA. But we certainly wanted our policymakers to be aware that these agreements did exist and that they should be interpreted to have some effect on the way we did business.
To the extent that there is a question about what, I'm sorry, there's a question in the back.
You raised case of Blockade. I wonder if you could talk about the executive order from last year on international regulatory cooperation. Maybe everybody could address how they're dealing with that.
Is that a question directed at me or at Catherine?
Well, you brought up case of Blockade, so I thought.
I will actually turn it back to you or to maybe one of my other colleagues at State. I do not actually address directly in my practice case of Blockade, so if anyone knows the answer to that question.
My understanding is that prior to the executive order in February of last year, there was no requirement other than case of Blockade for agencies to coordinate with their international counterparts. And a committee has been set up in order to require agencies to coordinate with their international counterparts and hopefully bring a more coherent aspect to transparency and other issues associated with international agreements. Case of Blockade, in my understanding, required reporting of international agreements, and the State Department was supposed to coordinate through the legislature coordination of those agreements. And I was hoping that the panel would address what has happened since the February executive order with respect to coordinating and the committee.
Certainly, several of you indicated that you do coordinate with counterparts. Jennifer, you're nodding your head. Do you want to address that issue and whether there's been an increase in cooperation since February of last year?
I don't think there's been any increase. I mean, by the nature of what we do, we have to coordinate. For instance, in the aviation industry, if we didn't coordinate, we'd have a whole lot of problems on our hand with simple air traffic control issues. And, you know, making sure that United and American and Delta can actually land in Europe and South America and don't get returned somehow midair. And in our cross-border issues with our rail and motor carriers, we've always had a really close relationship with either Transport Canada or the Secretary of Transport in Mexico. So I don't know if it's any new. I know on the regulatory level with our regulations, for the last several years, our Assistant General Counsel for Regulations has been very active in working towards regulatory transparency and regulatory harmonization on a lot of issues. I know we're working closely with Canada on issues. Mexico is still working on their regulations. SCT, the Secretary of Transport's a little behind on their regs, just making sure they're transparent with their own people. In coordination with us, we've worked with Japan before, China. We've been working with very closely for years, working on transparency issues. So I don't know if it's any new initiatives, but it's just an ongoing thing that we've done at DOT. Does anyone have any understanding or knowledge of the executive order that the gentleman raises that has increased your need to cooperate with your foreign counterparts?
I haven't, but I can tell you that I don't deal with Canada, but or Japan. Other people in my office do, but our folks meet with those two countries all the time, every couple months in person. So tremendous coordination because we have so many cases that involve those two countries.
And I've certainly heard reference to the executive order, but I haven't been involved in implementing it. I guess I would just say that, in a sense, it's sort of superseded by the new legislation that we've gotten recently that calls ever more explicitly for relations with our regulatory counterparts. So, in implementing that legislation, obviously we're moving toward the same goal of increased cooperation with our foreign counterparts.
I mean, I could speak to a few areas where we're doing a lot more cooperation, many of them outside of my office, but others at Treasury. One is, one in my office, the Financial Stability Board is something that was first started by the G7, but now is a G20 initiative, and really after the 2008 financial crisis became much more important. It's now a coordination body among the G20 to try to put together best practice guidelines and monitor how, let's say, they're handling financial institutions that are systemically important, so that 2008 doesn't repeat itself. Another area where I think we've got a lot more cooperation is in the area of sanctions, where the United States has been out front in dealing with that for many years, but we're seeing a lot more sanctions by the EU and other countries, and so we are doing a lot more coordination with them in that regard. And finally, the FATF, in the Financial Assets Task Force, is a area where we're put together recommendations on how to deal with money laundering. At least at first it was money laundering, and then it was counter-terrorist financing, and most recently it's been countering proliferation of weapons of mass destruction. Guess who that might be involved? And so we have been doing a lot more coordination of trying to get common standards and best practices and doing some peer review of how other countries are doing in implementing the recommendations.
Can I do a follow-up?
Please.
Can we take this a step further to the multilateral level, to the UN agencies that you deal with? How are UN agencies helping or impeding the coordination?
The coordination among agencies, or the coordination among countries?
Yeah, the coordination of agencies with their multilateral counterparts.
Sure. Several of you mentioned that you are involved in multilateral organizations. I think, Jennifer, you did, and Catherine also. So do you want to address those questions?
I think part of it's the UN itself that we deal with. I mean, we deal with several different, but our two largest are ICAO and the IMO. ICAO historically moves at a glacial pace, moving new standards. A lot of it's driven by technology, so you can't institute a new standard for an engine if the technology isn't there to build it. So a lot of those issues move kind of slowly, but through ICAO, we do a lot of our coordination with other countries. We use ICAO and the council there in order to develop consensus, where as opposed to the U.S. going off on its own and leading a charge that might be perceived badly. Even though we are the largest aviation market in the world, it doesn't necessarily mean everybody agrees with how we go about it. So using ICAO as a way to build consensus is really important. In IMO, I'm not familiar with how we work with that, but I know it's very similar. We use it to build consensus. So.
And we do have a great many interactions with multilateral organizations. WHO comes to mind since they have a public health mandate, as we do. I guess it's been I think we found it universally positive in terms of it being yet another forum in which we can interact with our regulatory counterparts. For example, the WHO is setting up a mechanism for member states to work on the control of SSFFC, which for Americans means counterfeit medical products, basically. And this is, again, a global issue. It's what's manufactured improperly in one country ends up being in other countries. And there's some very serious global public health issues associated with this. And in the context of this WHO-wide movement to provide some control to these over these products, we have many dealings with our counterparts in that context.
Let me actually, I'm sorry, Megan.
So I could add, in the technical assistance field, there are usually a number of organizations working in the same space, and it's important for us to coordinate with the UN entities in particular. For example, in Iraq, UNDP is working a lot with the state-owned enterprises, and we have a complementary program that is helping the state-owned enterprise create strategic partnerships with foreign firms. Also, UNIDO is doing a comprehensive review of the standards organization, and our collaborative efforts are important to ensure that there are not conflicting messages usually. Also, we utilize experts from the UN. We work often with UNCITRAL and with the World Bank and the OECD in hosting technical assistance programs.
Megan, since you have the floor, you mentioned in your introduction that your office is responsible for gaining some understanding of foreign or comparative legal issues. How does your office go about that task?
So we have a long history of working in the MENA region, and we were formed 20 years ago as a program with using USAID funding and commerce expertise to help post-Soviet states transition from public economies to private economies, and since then we've expanded to a number of regions. It's important for our staff to have an understanding of different systems and institutions and important legal policy issues to the United States. To get a better understanding, there's a lot of expertise that's built over time in working with countries in the region, and we draw from expertise, for example, in Tunisia for a technology transfer program that we'll be doing in Egypt, or we'll work with international institutions and experts in civil law countries on issues where we're helping build capacity in institutions that are different from U.S. institutions. For example, we worked with the French Conseil d'Etat to help build capacity in the Iraqi Shura Council, and we'll hold programs then in cooperation with foreign governments to try and provide the best guidance in terms of developing those institutions.
Open question to whoever wants to answer. How do you or your agencies coordinate on international legal issues with other agencies of the U.S. government? Do you look to those agencies for guidance on issues? Are there issues where you are required to consult with other U.S. agencies before arriving at a determination?
Yes.
Okay, Jennifer?
Yes to both. You mentioned the CASE Act. Whenever we, as just one of the other executive agencies, want to do a binding agreement with a foreign partner, we have to get, the State Department uses what they call the Circular 175 memo. Everybody's nodding. They've all had to consult on it, which goes through the legal advisor's office, and basically the agency advises the legal advisor's office and say, this is what we need to write an MOU on. And they prepare the memorandum of law that goes to the relevant undersecretary or assistant secretary of state to sign off on. In our case, it's under Secretary Hormats, which is in charge of the Economic Bureau. He signs off on ours. I've had to do a few myself now recently, so we always consult with that. I've consulted with a few, like I know Dave and I know each other because I've had to consult with him on some issues dealing with interpretation of free trade law. We're by no means experts on that. We always look to State Department and USTR for assistance. We know folks at the Commerce Department that we deal with on economic matters. Let's see who else I mentioned. Coast Guard, who used to be part of DOT but no longer is. We deal with Coast Guard on a lot of maritime issues, EPA and environmental issues, where we kind of are very open and honest that we're not the experts on all matters. We know our stuff really, really well, but we need help for everything else.
Anyone else? Gary?
There are a couple of different ways that we deal with other agencies. On the free trade agreements as well as the bilateral investment treaties, the mechanism we use is the TPRG, the Trade Policy Review Group. And basically the way that works is that at first at staff level, that's the TPSC, the Trade Policy Staff Committee, we have interagency meetings, and usually USTR chairs, when we're trying to figure out what our treaty provisions should be on issue X. If we can agree on that, we're done. If we can't agree, it then gets up to the TPRG, and that is will be comprised of undersecretaries or assistant secretaries who will get together and try to work out those issues. Hopefully you can. If you can't, then it goes up to the deputies, and it could, even in very contentious issues, go up to the cabinet. And it's a fairly formal process. The ultimate outcome we want is consensus, and if it could be that the president will tell what the consensus is. That's very rare, but usually at the other levels we work that out. CFIUS, the Committee on Foreign Investment in the U.S., we are the chair of that, and that is a very formalized process. There are 9 agencies in CFIUS, and we at Treasury, basically what they're looking at is when a foreign investment comes to the United States, the question is there, first of all, is it covered, but then secondly, is there, and controlled by a foreign investor, but then the question is there an issue of national security that gets implicated, and are there concerns involving national security that have to be addressed, either by entering into an agreement with the company concerned, or in the extreme case, blocking the investment or telling the investor that they have to divest, which is very rare, but it has happened sometimes. And on that, there is a process that we chair, but the agencies with the real national security expertise are generally whichever agency is most concerned, and defense-related products, it would be DOD, DHS for anything involving immigration or just possible terrorism. There's often the Energy Department's been increasingly involved in that, and wind farms, and have all sorts of security issues that people, I think, haven't anticipated. And but we do get together and have to come up with a consensus, and there too, if we can't do it at our staff level, it goes up the chain, and there will be at deputies level or even cabinet level. And ultimately, it is the president who personally, if you actually have to block something, and often the company would agree to withdraw their request, but if the company doesn't, it has to be the president personally who approves the blocking of a particular transaction.
Judith?
Yeah, we too coordinate with other agencies. Now, my particular division that I described, ATMA, Advanced Pricing Mutual Agreement Program, doesn't. But the IRS is a big organization, and I've been in offices that were coordinating with Treasury, as I mentioned, daily, all day long sometimes, hours and hours of meetings when it came to writing regulations and things like that. As I mentioned, Treasury does actually set the policy in those matters, on international tax. And then they work very closely with IRS attorneys and others. Well, we've got, a big part of it is litigation, obviously. If a taxpayer is audited by the IRS and doesn't agree, taxpayer has a couple options. One is to actually go to the tax court, which is specialized to deal with tax issues. It's such a specialized area. And the nice part about that, the advantage to going to tax court, is that the taxpayer doesn't actually have to pay the deficiency. Now, if the taxpayer has the money, and it could be an individual or it can be usually a big corporation, it could be millions of dollars, taxpayer can opt to pay the deficiency, pay the assessment, and then actually sue the U.S. government for a refund. And then the taxpayer, then actually it's the Department of Justice that would be handling the case and coordinating and actually litigating the case and coordinating very closely with our attorneys who set it up in our field.
Maybe I'll just add a couple of notes. As Jennifer was saying, we also are familiar with the C-175 process. Most of the arrangements that we have with foreign governments aren't intended to be binding, so that we use the word arrangement instead of agreement, just to make sure that everyone involved understands that this isn't an international agreement as under US law. But we do have to have those cleared by the Department of State. One of the things they're looking for is binding language that we might inadvertently have slipped in there. And interestingly enough, if the foreign government if they require a translation, then we either have to give the document to the State Department to translate, or we translate it elsewhere and submit it for a translation comparison to the Department of State. So I thought that was kind of interesting when I first encountered that. In terms of interactions with other agencies within the US government, one issue that can arise is if a trade dispute case is brought by a company that deals with FDA-regulated products. And in fact, that's how I know Dave. Such a case came up, and they came to the FDA to get the underlying information about the particular company involved and the very complicated US law that sort of underpinned the domestic complaint that kind of went along with the international trade complaint. There have also been cases where a free trade agreement has been negotiated or was in the process of being negotiated, and the foreign partner will want a particular annex or a particular section on pharmaceuticals, for example. And FDA is very alert to things like that, and we also try to consult with the negotiators and make sure that such an agreement wouldn't involve lowering our standards in terms of protecting the public health of the US consumers.
So it sounds like there's a mix between informal cooperation between agencies and, as Gary indicated, in some instances more formalized groups required to make certain determinations. Megan, you mentioned that part of your job is assisting other countries in understanding and implementing their international obligations. So in developing programs like that, how do you determine what those international obligations are such that you can provide that assistance?
Certainly, I said that we work often with USTR, and as a part of that, we help our trade partners meet their obligations under the free trade agreements. And we work in areas of intellectual property, standards, customs, trade facilitation issues, and procurement. And but we defer to USTR to decide in terms of where issues arise in the negotiations, and we work at the request of the foreign government.
Yes. Yes, oh, thank you. There are two questions. Sarah.
If I could just ask, you earlier commented about how you work among federal agencies together. A question for any of the panelists. What do you see as your biggest challenges when you're working on interagency problems, and then how do you resolve that?
That was going to actually, similar to my next question, how do you resolve conflicts if agencies can't agree, at least not initially?
Well, I've been involved in a fair amount of those.
Gary and I have been in conflicts against each other.
And you know, the type of situation that Dave talks about is, in our case, you know, when the United States is they can be subject to investor-state arbitration claims under our investment treaties or free trade agreement investment chapters, and State Department is responsible for defending the case. They do a very good job, and our job is to make sure they don't do too good a job, because they have won every single NAFTA case so far. The problem that we see from time to time is that our interests that we're looking out for, as well as USTR and Commerce and even part of State is also looking out for, is the interests of outward US foreign investors who are investing overseas. And if State Department makes an argument that is of the type of, you interpret provision X to say the government always wins in that provision, that often will not be to our liking. So what normally happens is that State they'll send out a draft of their brief on a particular subject, and then if we have a problem, we proceed to mix it up and try to do our best in coming up with the best arguments on the merits. Generally, we try to do it at staff level. ultimately, sometimes we can work it out, and I think that state over the years is, I'll have to concede, looked at our arguments in good faith, and if a number of agencies can get together and make convincing arguments, and particularly the part of state who's also interested in our outward investment treaties, they may get involved as well. And often we can work these things out just among ourselves at staff level. If we can't, you elevate it. And that's always the question. Sometimes I can think of cases where someone in the state says, well, forget it. We've heard you and we're not interested, but if you're really interested, you've got to elevate it. And then the question is, will our superiors be that interested in this particular issue? And sometimes they will and sometimes they won't. And we've got to sort of gauge, figure out if they won't in a particular issue, we'll just do our best at staff level. And ultimately, state is defending the cases, so generally they would get us, we do want to win the case, so they get a certain measure of deference, and we're not going to challenge them in a number of situations. But if it's a very important issue and we think that our superiors will be interested, just from what we know about our superiors, then we will be more inclined to elevate it. And particularly if we can get a group of agencies involved on a particular issue who also have the same interest, we are more likely to elevate it than if it's just us.
I agree with that. We try to solve it at the staff level, try to do it through just discussion. Sometimes it's just every agency is coming from their own mission as to what they want to achieve, and sometimes those missions are at cross purposes, and other times you just don't know what the mission is of the other agency, so it's just simple ignorance on the part of somebody. Sometimes in your own agency you have to educate people. It's like they actually have a reason for saying what they're saying. Occasionally it requires escalation to senior staff and even to the political level. You hope not to the secretarial level. But there is, being that we're all part of the executive branch, there is the White House, and especially in international affairs, there's the National Security Council, which kind of oversees international policy for the government. You try not to have to involve them, but occasionally it requires a phone call to one of the NSC people who has to coordinate, and you hope it doesn't make it to that point. But sometimes it does take that, so you have almost like a parent in the room to listen to all the kids, and then they come up with a decision.
Jennifer, I was wondering if we could actually talk a little bit outside of the executive branch and get into the legislative branch. You mentioned that your agency, or one of your roles and one of your office's roles, involves the International Law of the Sea. Mm-hmm. Of course, which has not been ratified by the United States. So I was wondering if you could describe a little bit more what your agency's role is with respect to the International Law of the Sea, and how you deal with it in terms of not being a ratified treaty of the United States.
That's where we kind of default to our international law schooling, where if it's not a ratified treaty, so it's not U.S. law, it becomes customary international law. Because if all of our partners have ratified it, and they're going to impose their will on us anyway, or attempt to. We deal with it. We have our Maritime Administration that we deal specifically with it. UNCLOS actually, in some respects, also applies to aviation. We use the similar boundary lines, so 12 miles for territorial waters, and then the economic zone, high seas, that goes straight up as well. So we deal with it as more of a customary international law issue. I know we deal with law. I personally don't deal with law of the sea. It's one of my coworkers. He's the maritime guy. Right now, they're actually working on an issue dealing with piracy. And I know they're dealing with, I think, Commerce and DOD, about half a dozen agencies, on trying to coordinate a piracy, something dealing with piracy, but I'm not involved in it. But it sounds really interesting. But personally, I've dealt with the law of the sea problem with dealing with the definitions. It comes up at the weirdest times. I did an aviation agreement with Indonesia. And territory is generally defined as your land plus territorial water out to 12 miles, and it goes into the airspace out to 12 miles is your zone. Indonesia is a weird, because they're an archipelago, and they kind of only have 7 miles between them and Singapore. So they're really, so they don't have, it really like splits down the middle. And they were trying to change the definition in our agreement to modify their definition in law of the sea, which they have a special definition for territorial waters because it's an archipelago. And so I had to do maritime research to realize what they were asking for. While our secretary was actually in Bali before he signed an agreement, we almost had to stop a signing because of that. So.
On the question of coordination, maybe 2 or 3 last questions actually. Have you ever had a situation where a decision made by your agency affected another agency, or vice versa, where a decision undertaken by another agency affected what your office or agency had to do in terms of its international legal obligations or its international legal thinking?
Often that's happened, and so I guess the question is
sort of unilateral decisions, yeah.
Yeah, I mean, a lot of in our FTAs, and this is one area where we at Treasury take the lead in all of financial issues. There are a number of other agencies who are very interested in financial issues. The Federal Reserve Board and the SEC in particular, as well as the CFTC. They don't have the resources to negotiate all of our agreements, so they pretty much rely on us to do it. And there have been times when I mean, we will have to clear everything with them, but there have been times when basically the agencies who are interested in protecting our investors overseas are trying to get a particular provision into our treaties, and we sometimes have made decisions that you think you've cleared it with someone, and then down the road someone else in the agency realizes some particular aspect of it that they hadn't thought of before, they hadn't been consulted on it, and then the question just comes up, how can we reverse that? Sometimes, when it's in the beginning of a very long, protracted negotiation process, and you're up to the 15th round of a negotiation, and all of a sudden you realize that there's this issue, maybe you can pull yourselves out of it. Other times, if it's after an agreement, then it's trickier, and you try to come up with some interpretation or something to get yourselves out of the issue you've gotten into. But we try to avoid it as best we can through coordination, but you just don't always get everyone who a particular angle involved, and sometimes you have to pick up the pieces as best you can.
We find Congress has been more involved in dealing with our international relations than their agencies. We've had several instances where Congress has imposed new laws and new regulation, or instituted new laws where we've had to go to our foreign partners and explain how whatever we were going to do has got to be delayed or stopped. And sometimes Congress is helpful in that they put forward a law that sends a signal to the foreign partner. The EU ETS is the most recent example. Congress is very upset about it, so they passed a law saying in Secretary of Transportation, don't make any airline pay anything. And that actually caught the EU's attention probably more than us sounding alarms.
FDA was involved in an interesting matter recently. Well, starting in, I believe it was 2009, the United Nations Environmental Program decided that the member states should negotiate a treaty or a legally binding international instrument on mercury, anthropogenic mercury, sources of mercury that humans put into the environment. So the 43 member states agreed this was a good idea, and negotiations began, and they just finished this January, just last month. And it was interesting because, of course, the UN Environmental Program has an environmental mandate. The US government This came right from the White House that President Obama was in support of this kind of a treaty. So, clearly there was a mandate in that respect. The lead negotiator for the delegation was the Department of State, but for some of the provisions that involved FDA-regulated products, it was the EPA who was the primary negotiator. And we had many interesting conversations with the EPA because there are, even if you say you're only talking about public health, there's different kinds of public health. The FDA believes that products that are on the market that we regulate that contain mercury provide, we've done a risk-benefit analysis. We find they provide a public health benefit. However, the EPA has its own approach, its own risk-benefit analysis that it does. And so we had many hundreds of hours of discussions with EPA as we tried to find something that would meet their needs and also protect what we perceived as important public health interests.
Okay, stepping back then from the mechanics on a more theoretical level, since this is the American Society of International Law, and sometimes we're a little lofty. How do you view your agency's role in the development or expansion of international law? Is your agency promoting, or I suppose also foreign and comparative law and cooperation? Is it sort of a promoting international relations and international law? Is there a sense of, at times, holding back the tide from an expansion? Is it neutral or indifferent? Does it depend on the administration? If you could just sort of speak, stepping out of your day-to-day role and thinking more theoretically.
Well, I can speak to some of it. I think that you just have to look at it issue by issue. It's very different on particular issues. And in some areas, like what I talked about before on things like the Financial Action Task Force, we have been in the lead of trying to get other agencies to put controls on money laundering and terrorist finance and weapons of mass destruction. Clearly, we have taken the lead. In the anti-corruption area, we were sort of the ones who were out there in front of everybody else for the OECD convention anyway, and we are now in front of other countries in the free trade agreements having anti-corruption provisions. And we think there's a nexus between having a corruption-free environment and promoting the fair rules of international trade. Some other countries aren't, so we're pushing that in Treasury. I mean, we're actually agree with other agencies on that. But in other areas, in investment treaties, we like very high standard investment treaties, and the U.S. investment treaties, if you compare them to those of other countries, I think you would generally find, not every area, but most areas we are high standard. So then the question is, there have been initiatives over the years to have these multilateral investment treaties of different kinds. We're right now negotiating the Trans-Pacific Partnership. But before this, back in the times of Doha, there was a movement by a lot of countries to have a global investment treaty on certain, or global investment agreement on certain areas. And we felt that it was an area where if you had a global agreement, we would go to the lowest common denominator and we would not have the kind of high standard agreement that we'd like to see. So even though we'd give up having a global agreement, it was much more important to us to not have it at all and try to negotiate these things bilaterally. In the multilateral development banks, it's some areas you just have to look at the particular subject matter, and Treasury and Congress often is pushing us to make sure they have good accountability mechanisms. They have inspection panels that if any indigenous people or NGOs find that they have been harmed by a particular World Bank or Regional Development Bank practice, that we want to have an independent panel to take a look at that and to tell the bank what they've done wrong and try to correct it in the future. A lot of the borrowing countries don't like it, so we've been taking the lead and trying to push that. Other initiatives in the, let's say, the World Bank, there's an issue called country systems, where a lot of the borrowing countries in particular, and like the BRICS, the countries that are getting more sophisticated, are saying, hey, we're borrowing countries, but we don't really need the World Bank rules. We're sophisticated enough to have our own rules. We ought to take ownership of these programs ourselves. And we should have, and with the banks, a country system so that instead of using the World Bank rules for procurements, we should each allow the bank to defer to our own rules about it. And Congress, as well as our business community, has a lot of reservations about that. We think a uniform standard of bidding documents, for example, across the agencies is better than having these country systems. So we are pushing back at that. So it's a very issue-by-issue analysis.
Judith, did you have thoughts?
Yeah, as I said a couple times, we don't make the policy in the IRS, but you know, it's Treasury that does. But this really bears emphasis. We, believe it or not, and really not believe it or not, in all seriousness, we in the IRS want to get to the right answer. And we want to do things in a very principled manner and whenever possible in a practical manner. But when we are negotiating with other countries, we do it in a very principled way. We're not pushing the envelope. We're not holding back. We're not indifferent. We're trying to get to what we think is the right answer. And this is carries across the whole board with the IRS, whether it's agents in the field auditing or whether it's field counsel actually litigating cases. We're not looking to extract the greatest sum of money from the taxpayer. We really do want to get to the right answer. Most of our treaty partners are pretty good. Some are really very, very reasonable and very practical and principled. We've had, I don't want to say the countries right now, but we've had countries where it was more difficult, where and there still are some, there are a few, one in particular, and there's some public comments about that, that's all I'll say on that. But we've had countries where they haven't been as reasonable in the past, and what's interesting is we now have arbitration provisions in our treaties with these countries. And it sure helped at least one of the countries become a lot more reasonable. What happens is it's called baseball arbitration, so it's all or nothing. And if a country takes a very unreasonable position to this three-person arbitration board, it will lose. So it's not to the country's advantage to do that. And so we have dealt with other countries that really were taking pretty egregious positions.
Does IRS represent itself in those arbitrations, or does it bring in litigation help from one of the other agencies?
It actually represents itself. It writes briefs, and it picks. I think each country picks one person, and then to negotiate. I mean, as an arbiter, and then I think the two countries mutually agree on a third. And these are experts, so it's a three-person.
Megan?
I'd say by promoting understanding and helping countries understand the benefit of certain international frameworks, we encourage the adoption of some international law and develop the political will for that. But often in developing countries where there will be the political will, but there won't be the capacity to meet some of the obligations. So our work in technical assistance is important in helping them meet those obligations.
I might add from my personal experience that I think the answer to my question may depend on sort of the outside viewer more than whether we have a particular view of it. I don't think, certainly from my point of view, we are looking to expand or retract or do anything other than apply international law accurately. But my practice is in representing, a little bit coordinating with Gary, as he said, representing the United States in international arbitrations arising from our investment treaties. And certainly we have been accused of having two heads with respect to these treaties, that we negotiate many treaties. They have protections of investors that many people would interpret very liberally, but of course in defending these, the United States in these arbitrations, the State Department, as Gary indicated, may interpret these provisions more conservatively. And so we have been accused of speaking out of both sides of our mouth, I guess, of promoting very strong investor protections, but then when the United States is a respondent in these arbitrations, interpreting the provisions more narrowly. Of course, we would deny that we have done that. It is merely the application of the terms as we understand them. It's actually a great time for questions. We have, I suppose, about 15 minutes left in the presentation, so we would love to hear from you. So first there.
Thanks very much to the panel for a very diverse, informative presentation on international law and various agencies in the U.S. government. My question is actually related to this last strain of the conversation about getting to the right answer, I think, as Judith was saying, and as you put it, David, representing international law accurately and pronouncing judgments on accurately. And I'm wondering, maybe going back to the previous conversation we had about the logistics of interagency coordination, how the default rules on who is the lead may actually kind of set a little bit of a bias on where that right answer is going to turn out to be. And so I'm curious about if the panel could inform us a little bit about how that process of determining who is the lead agency, where does that power, when that power starts, that can often determine where you end up at the end. And I'm curious if you could tell us from your experience how that lead agency determination is made. It sounds like in some cases, as Catherine mentioned, it may be a lead on an overarching negotiation, but for particular issues, there's a different lead agency. A little bit of background on that would be really interesting. Thanks.
If I might mention to start, in my particular area with the investment treaty arbitrations, we do things a little bit differently. State and my office is the lead on those issues, but of course the treaties themselves are negotiated by USTR and Treasury and Commerce and others. And there is a state office, as Gary mentioned, involved in that negotiation as well. In Canada, we have conversations with our counterparts in a lot of these treaties. Canada has one office that both negotiates and defends the arbitrations under these treaties. So they actually have a simpler system where everyone's all in one office, and if you negotiated a treaty, you may end up defending under that same treaty. But I think in terms of this particular activity, it's a very interesting dichotomy between taking the lead on the negotiating the treaty and then taking the lead on the defense of the treaty.
Let me comment on some experiences we've had in the TPRG, of course, and not mentioning the specific instances, but I can definitely recall many types of questions come up and staff disagree on a particular question, and then it goes up to the TPRG. So you have your assistant secretaries, undersecretaries, and often, the first thing is, if an agency brings their undersecretary as opposed to the assistant or deputy assistant secretary, right there, that'll sort of show they have more of an interest in it. So if you really want to make your point, you will have as high a person as you can to be there. Secondly, in most issues, I think people have a general sense of which agency should know the most about it. An environmental issue, EPA will be sort of the lead on that, and anything related to the courts, justice, people will listen a little bit more. But at the same time, it really often will depend on the personalities involved and the general assessment in these rooms of what, how good the other people are. And I can think of a number of instances where agency X, who you wouldn't think was really that concerned with it, would just have a representative at the TPRG who is very persuasive, and the agency who ought to be more concerned about it didn't, and they were able to persuade other people around the room. And generally, if you can kind of win over the room, you can win on many of these things. Other times, what might happen is that let's say the losing agency does get kind of rolled by everybody else at the meeting, and they say, hey, this is our area, this shouldn't happen. Then they will often, you still need a consensus, so they will push it up to the deputies. And I've seen that kind of thing happen as well. With just a particular meeting is not going well, they figure, okay, let's get out of this one, and we think that ultimately at the deputy level we can do better. And certainly a lot of interagency disputes that I've been involved in, it often depends on ultimately who's on top, and because basically the implied premise, you don't always say it, is, gee, we're gonna, if we disagree, I'm going to go to my boss, and my boss is going to be listened to better than your boss on issue X. And often that's how it ultimately will get resolved. Just without even going to them, people know that, gee, on this particular issue, there's no way that this guy at the top will overcome the other guy.
As Jennifer mentioned, you hope that it doesn't get there, and it, I think, very, very rarely gets there, but ultimately the White House would make the decision. So as Gary said, sometimes it's even who has the White House's ear better on this particular issue.
And that's just connections.
Wes.
So I'll throw one out for you. You all obviously deal with very specialized areas of law that also happen to be international areas of law. So how do your agencies, I guess, and this may be personal as well, how do you find the people that find those two interests overlapping to staff your agencies, to find the right people? Because obviously, if you're not someone who likes this international area of it or likes the very technical side of it, it can become a very tedious job. So how do your offices go about identifying the right people, and what do they look for when they're looking for the people to staff their agencies?
I'll admit it's really hard, especially in the legal sense, to find somebody with transportation law background. I think there's 5 law schools out of 190 that teach aviation law. There aren't any that teach motor carrier or bus safety law. I'm going to tell you that, right? If there is, I will be like the first to go sign up for a CLE with them because I don't know nearly enough about it, even though they're my clients. For our office, since we actually just hired somebody the year before last who actually had been an intern, and I had been an intern before I was hired. A lot of time, we look for people, because transportation is something, like I said, you can teach somebody transportation law, provided they have an interest. Normally aviation's an easy one, everybody likes airplanes. But the international background we think is really important. It doesn't have to be international law, it helps, but international policy, an interest in an area of the world, because if you're not interested in the world, then we kind of don't want you. So.
Well, I think for FDA, our Office of the Chief Counsel looks, I think, first and foremost for good lawyers. So somebody who's been to a good law school, ideally somebody who's been practicing food and drug law. But there is a feeling that you can bring on a good lawyer and train them in food and drug law. We did not, when I was there, spend time really training people in international law. Sometimes there was an opportunity to take a class at the State Department or something like that, but it wasn't something, or at FIDLI, the Food and Drug Law Institute. But it wasn't really an area where we were involved in training. I think actually, I mean, frankly, I think FDA, many policy parts at FDA have realized that we have to have more and more of a global outlook. And I think this is something that our legal office also is in the process of developing, but probably doesn't have the depth and staff that would be good to have given those developments.
Gary, you have an international legal background, right?
Yeah, in large part, I think it depends on who is running our office and doing the hiring and what their priorities are. I think in my case, I can think more recently, our bosses are more interested in someone overall being a good lawyer and strong writing skills and analytical skills and the like, and the international experience is secondary. Others I can think of in the past have been more interested in, gee, who is going to stay for a long time and really be interested in it, and that is sort of a higher priority. And look at, particularly for us, not just international issues, yes, that's important, but international economic issues that might not be just a foreign policy person their forte. So we look for that kind of thing. But it really depends on who is the ultimate hiring person.
I think that for a tax lawyer, it's certainly helpful to have an LLM in tax law. Now, not everyone does, but during this will really date me and show you how long I've been around, but during the recession back in the early 90s, when top partners were trying to get entry-level positions in the IRS, Office of Chief Counsel, etc., everyone needed to have an LLM to get in. I don't think it's quite like that now, but certainly it helps. For litigators, if it's a field position litigating, then certainly litigation experience helps. In my immediate organization, transfer pricing, we there are a number of people out there in private practice who do have transfer pricing expertise, unlike in your situation, Jennifer. And so that would be ideal. We look for lawyers who have that experience and expertise, We look for people with an economics background. That's always really, really helpful. People with accounting backgrounds, people with a real understanding of businesses, so MBAs help. It could be an undergraduate degree, it could be a graduate degree. And a lot of people, you know, we did have a big hiring effort when we staffed up our new organization about a year ago. We must have hired, I'm guessing, 50, 60 people. Or, I mean, a number, probably a good 50 or 40 or 50. And most of them did have some good experience. We were looking for that, but we did take people who did not have that experience. They were just, as others on the panel have mentioned, just smart people, good lawyers, good, strong people. And everyone is to some extent, and those people in particular, learning on the job. So we are willing to take people who are just really, really sound, good, solid people and have them learn on the job.
Since we went around the horn, let's hear from Commerce, and then I think there was one more question.
So we're a little unique in that we have a less narrow focus. We work in a variety of different business and commercial law areas, and but for us it's important for them to have, we have a very multicultural staff. We have a number of native speakers of foreign languages, and because we work regularly in the foreign language, and an understanding of different systems and of legal policy.
Somebody had a, yes.
Yeah, going back to the development of international law question, I'm just curious how all of your different agencies, how much you get ahead of the curve on issues, like issues that you see coming down the road, how much time and energy your offices might devote to those issues. I'm thinking of two in particular, the space travel industry and the opening up of Arctic for shipping lanes and things like that. Just those two issues that are way down the road. And really kind of leaving you here, but anybody, how far ahead your agency stay of issues that may come down the road a little later, or do you really focus on what's present and current right now?
Lucky for us, there's actually a space law office at FAA, so they deal with that. And the FAA's Office of International Law is the one who gets tasked with dealing with the International Convention on Space. I don't think we've dealt with it in 20 years, which updates me, which is the good thing. The Arctic stuff, actually, my coworker, the maritime expert, actually was one of the drafters of the Arctic Search and Rescue agreement. And we tend not to be too forward-thinking. We tend to be more reactive. Case in point, Mexican trucking being the best example of that. We tend to be more reactive in a lot of those issues. But we are forward-thinking in the search and rescue context. I know we have several initiatives going with that. But we tend, at least my agency tends to be quite reactive. Where things happen, we get mandates from Congress or we get mandates from the White House to go forward and go do something.
Judith, it sounds like your new program is very forward-looking in a way, no?
It is. It's different. Well, it's comprised of two that already existed, but it's much more efficient. We were greatly understaffed in the former APA program, and here taxpayers are trying to enter into advanced pricing agreements. I'm putting the emphasis on advanced, say for a term of 2008 to 13, and it didn't get signed until 2013 or 12. I mean, 4 years had passed, and we could not get the budget for more people. So we and there was also another, so we combined, and there was another advantage to the combination. It's that there isn't a handoff. The way it used to work is the advanced pricing agreement folks would actually come up with what was called the recommended negotiating position, and then it was actually the United States Competent Authority folks, the other part that was combined with those, who actually negotiated with the foreign countries. So there was an inefficiency built into the system. There was what they called the handoff. And so this actually makes it go much more smoothly. In terms of the IRS, though, in general and the whole field audit function, if you think about it, the field is generally it's auditing past years. Now we've really come, it used to be years ago, maybe 20 years ago, auditors were years and years behind. They were auditing cycles that had passed many, many years ago. There was a huge initiative maybe 15, 20 years ago, and now we're not that behind. We're auditing, years, you file your tax return, say for 2012, you file it in 2013, and the IRS might be auditing it a year or two after that. So that's really good because some of these are really, really complicated transactions and audits. But I lost my train of thought. I'm sorry, what was the question again?
Just whether that you're anticipating issues that are
okay.
That are going to
and so we were sort of behind the 8 ball. Tax, sometimes people, specialists in the field would say, oh my God, we've got this emerging issue and that emerging issue, and we would call it our Emerging Issues Initiative. But it was so hard, just some of these rulings and the regulations and the case law and dealing with different organizations within the IRS. I would say we were much more reactive just because of just resource constraints more than anything. And so we couldn't say, oh yeah, this is what's going to be happening in the future, especially before the tax returns are even filed. So I would definitely think we're more reactive.
You raise an interesting issue in terms of just my personal experience. I know that my office does think ahead in terms of legal issues we see around the corner, and we'll dedicate some research into thinking about how they're going to play out, arguments that are going to be made. I can't say that there's any sort of interagency coordination on those questions because there's no need if the issue hasn't quite been presented yet. It's more just trying to stay ahead of the curve and stay educated. But your question makes me think, maybe we should check in with other agencies who may be dealing with similar issues and see if they are also thinking ahead of the curve on those questions and see if we're arriving at the same answers. Otherwise, when the issue is presented, we may end up at loggerheads that you try to avoid. With that, I hate to hold us up from cocktails and hors d'oeuvres, so I wanted to thank the panel for their participation. Also, thank all of you for your great questions. I think that we're all planning to stick around and have a drink, so if you have any others, please do stick around and ask more questions. Thanks very much.